'cause you can't, you won't, and you don't stop. Or when you can't, you won't, and you don't stop. Mike D coming down for sure.
Having looked at how we've ended up with the legal system that we do, and also the various powers that are separated between the Commonwealth government and the state government, we've now got to delve into each of those levels of government and how they operate. Specifically, we want to look at the legislature, the executive, and the judiciary and the interaction between them. The first topic to discuss as part of that role is the separation of powers. So the separation of powers says that in the three arms of government, we need to distinguish the power and not have the same group have all three of these powers. So the first power is the power to make the law, legislative power. The second power is the power to administer the law, or executive power. And the third is the ability to interpret and apply the law, which is judicial power. So legislative power, or the power to make the law, is in Parliament, federal Parliament or the state Parliament, depending upon which level of government we're talking about. In that sense, it's a reflection of our system of government as a federation. So the Parliament are elected representatives that make laws on behalf of the citizens. That's why we're a liberal democracy. The law that they make is called legislation, statutes, or acts of parliament. They all mean the same thing. Now, the executive is probably what you run into most in your everyday life in terms of what you think about government. That's the area that administers the law. Again, federation is important because at the Commonwealth level, we have a Prime Minister and other ministers. And at the state level, we have the Premier and their ministers. They implement and administer the law with the departments, okay? And so the various departments, say within a state, are based upon the residual powers. So there'll be a minister for education, for instance, or a police minister, okay? So, whereas at the Commonwealth level, they will reflect the powers that are given to the Commonwealth and the concurrent areas that the government wants to concentrate on. So because we are a responsible government, the executive is a subset of the legislature, and so we don't have a strict separation of powers. However, we do have a strict separation in terms of judicial power. Again, because of federation, there's a Commonwealth series of courts and state-based series of courts. These hierarchies are ranked courts according to their jurisdiction or the level of case that they can hear. This allows for the operation of doctrine of precedent, which we're going to get into in the next module. Essentially, by having a hierarchy, higher and lower courts, we get a system of appeals, we get the most experienced judges hearing the hardest cases, and the operation of the doctrine of precedent. And as I've mentioned, I think 3 times already, the basic idea of the separation of powers is the legislature, executive should, as far as possible, remain functionally separate. So the same person shouldn't be part of more than one of the 3 arms. One arm of government should not control or interfere with the other, and they should not exercise a function of another arm. We see a stricter separation of powers in the US, where we clearly have the executive being elected through an entirely different process to the legislature and then appointing who they want to run their departments. But in a Westminster system like Australia, we operate under the doctrine of responsible government, which means we do not have a strict separation between the executive and the legislature. So we've been through what law is, we've been through Australia's legal system. So now let's see how that system operates. How is law actually made? There's lots of factors that can drive change in the law. political change, problems in the law, community values, lobby groups, changing technology. All of these things might require us to change the law. Now, because we have two sources of law, there are two ways that the law can change. The first and most common one, or the most visible one that we will see, is where Parliament, either the federal or the state Parliament, depending upon the constitutional power, can pass a law. Okay, so we can legislate a change in law. This is how we get rapid, large changes in law. Alternatively, a court in a hierarchy can make a judicial decision that creates new law. For instance, the High Court reconsidered that principle of terra nullius in the Mabo case and inserted the doctrine of native title into Australia's legal system. There was nothing legislated about that, and that is a hallmark of our common law system, that we have two sources of law. Let's deal with the most common one first, which is legislation. How does legislation come about? How does it become law? Well, the first step is there's obviously a series of potential ways that the issue can be raised. Here we've just got a spectrum of the potential stakeholders who might raise an issue that then gets taken on board by members of Parliament, generally a political party. In fact, a political party might come up with a solution for an issue and take it to the people as part of their platform for being elected. But how does that proposal for a new law actually become a law? To understand that, we've got to understand the structure of the legislature. So most parliaments under the Westminster system, which is the British system, and then here in Australia, have two houses of parliament. We saw in the evolution of the common law system that was traditionally the House of Lords and the House of Commons. In Australia at the Commonwealth level, what we have is the Senate and the House of Representatives. Now, the basic idea, why do we have these two houses? When we federated and the colonies came together to form the nation, what you could have been a little bit worried about is that if we only had one vote, one value, then all of the states that had the most people would make laws that were good for them. So the laws would be made with a concentration on, say, New South Wales and Victoria, at the expense of all of the other states, Queensland, Western Australia, etc. And these states might have different needs, different priorities. So the question was, how do we balance that? How do we get representative democracy, where roughly everyone's vote is equal, with different groups in different geographic locations taking advantage of one another? This is where the bicameralisation of Parliament into two houses comes in. So in essence, there's roughly the same number of voters for each member of Parliament in the lower house, in the House of Representatives. One vote, one value roughly in the House of Representatives. It's very different in the Senate, which is called the States House. In the Senate, the states all get the same number of senators, right, irrespective of how many people there are in the state. Then the third element that we have is we have these two houses. We've got the House of Representatives and we've got the Senate, and we've discussed why we have the two houses and what was the logic behind them. And then we also have the representative of the Crown, because we're a constitutional monarchy, the person who can oversee any problems if problems were to occur. Remember, it's largely a figurehead position that operates via convention. There's no rule, but they will tend to operate a certain way in order to give certainty to our system. Most of our parliaments are bicameral. Queensland is unique in that it's unicameral. We have a constitutional monarchy in that the Crown must assent to it. There must be royal assent, which is when the Governor-General at the Commonwealth level or the Governor at the state level signs the actual bill into law. Federal Parliament has two houses since Federation. I think I've been through the structure and why we have that structure, and I can leave you to read that. So how does a law get made? Okay, first, it'll get drafted into a proper legal form, which is called a bill. A bill is just a proposed law. The bill is then introduced into Parliament. It can be either upper or lower, but most start in the lower house. Within each house, there's a process. So we've got a proposal, we draft it into a proposed law called a bill, it goes to the lower house. In the lower house, there are then 3 readings of the bill. Why do we have that? Well, it's a check and balance that allows everyone in this House of Parliament enough time and resources to read and understand the bill. If it passes that house, it goes to the second house, in this case, the upper house, okay, which federally we'd call the Senate. So if it passes the House of Representatives, it then goes to the Senate. If it passes the second house, it gets royal assent. It's signed by the Crown, which federally would be the Governor-General. Okay. By convention, the Governor-General or the Governor at a state level will always sign a bill that's passed both houses. After it becomes royal assent, the bill becomes law. Generally, there'll be a commencement date when the law will start. Most states have a very similar process. At the lower house, it'll be called the Legislative Assembly, and the upper house will be called the Legislative Council. The big difference is in Queensland, of course, where they abolished the upper house, right? So there's only a Legislative Assembly. It's roughly the same process, only that there's no second house to get through. So there's no check and balance. There's no bicameralisation. If you can get a bill passed by the lower house through the 3 readings process, then you can make a law, which is a lot easier in Queensland.